My name is Tyng, and our video examines the current legal framework in Malaysia regarding child marriage with comparisons to the law in England and Wales. I'll be explaining the definitions of child marriage as well as the Malaysia current legal framework on child marriage. UNICEF defines child marriage as any formal marriage or informal union between a child under the age of 18 and an adult or another child. Globally, the practice of child marriage has been continued to decline. As of May 2023, 1 in 5 young women aged 20 to 24 years were married as children. In the case of Kamaria and No Asmira, the Sharia subordinate court judge had allowed applications of marriage for a young girl who is only 15 years and 2 months old under Section 8 of the Islamic Family Law Malacca Enactment 2002, which allows the marriage to be solemnized with the permissions of the Sharia judge. This case reviews the current situations of child marriage in Malaysia. Child marriage remains a pressing issue, with the statistics showing that an average of 1,500 children get married yearly until 2018. It is estimated that 83% of Muslim children marry compared to 17% of non-Muslim children, making this a serious concern within the context of Islamic law. Most of the child marriage cases in Malaysia involve females minor marrying men older than them. This raises serious concern about sexual exploitations and the deprivations of educations for young girls. Despite the enactment of various laws aimed at protecting children, including the Sexual Offences Against Children Act 2017, there is an ongoing debate about whether this legislation adequately addresses the issue of child marriages. This video critically examines the current legal framework in Malaysia regarding child marriage with comparison to the law in England and Wales to determine whether Act 792 should be employed to combat this practice. Malaysia's legal framework on child marriage presents a complex picture. A child has been defined as a person under the age of 18 years. Section 2 of the Age of Majority Act 1971 clearly states that the age of majority should be age of 18 years. However, Section 4, subsection A of the Act creates an ambiguity by also stating that it does not affect a person's capacity to marry, which in other words, underage marriage is allowed. The legal framework governing marriage is complicated due to the coexistence of civil law and Islamic law, and the legal age of marriage varies across different jurisdictions. The legal system governing marriage and divorces of non-Muslim falls under civil law, particularly the Law Reform Marriage and Divorce Act 1976, while the Muslim community is governed by the respective state Islamic family law. Section 10 of the Law Reform Act 1976 says that the minimum age requirement for both males and females to get married is at the age of 18. However, for a female who has completed her 16th year, the solemnizations of such marriage was authorized by a license granted by the Chief Minister under Section 21, subsection 2. The legal system governing the marriage of Muslim is under the Islamic Family Law Federal Territories Act 1984, IFLA 1984. Section 8 of the IFLA 1984 provides that no marriage may be solemnized under this act where either the man is under the age of 18 or the woman is under the age of 16. The exception to these rules applies when the Sharia judge has granted his permissions in writing in certain circumstances, such as the female under 16 years. This disparity between Muslim and non-Muslim minimum ages creates a fragmented legal landscape that complicates the protections of children from underage marriage. Malaysia has the Child Act 2001 and the Sexual Offences Against Children Act 2017 to safeguard and protect children. However, neither of those had directly addressed child marriage. This creates a legal gap where cultural and legal exceptions allows child marriage to persist, potentially outside the scope of child sexual exploitation. The Child Act 2001 served as Malaysia's cornerstone legislations for child protections. It was enacted to acknowledge that children require special safeguards, cares, and assistance to provide protections and assistance in all circumstances without regard to distinctions of any status. The Sexual Offences Against Children Act 2017 was enacted with the provisions to safeguard children from sexual crimes, including child pornography and sexual grooming. However, neither of this specifically addresses child marriage. Consequently, child marriage often falls through the cracks due to the cultural and legal exceptions and creates a legal loophole where child marriage may not seen as a form of sexual exploitation. While the Sexual Offences Against Children Act 2017 provide robust protections against various forms of sexual exploitations, its applications to child marriage in Malaysia is limited by existing legal exceptions and cultural norms. The existence of law permitting child marriage presents a conflict with the aim and provisions of safeguard children from sexual crimes. Our video will further discuss in order to effectively combat child marriage, whether Malaysia needs a unified legal standards that raises the minimum age of marriage to 18 across all legal systems without exceptions. Should this reform be complemented by strengthen the enforcement mechanism under the Act 792 to safeguard children from child marriage? These questions will be further discussed in the video.
Hello, my name is Ravena, and I'm going to talk about the current position of England and Wales in child marriages. In recent years, the law on child marriages in England and Wales has evolved significantly. The law today expresses an improved understanding of children's rights and the need to protect them from the risk associated with child marriages. Previously, in Section 2 of the Marriage Act 1949, the legal age for individuals to get married in England and Wales was 16 or 17 years old, with parental consent. This provision caused public outrage as it did not provide adequate protection for vulnerable children from being forced into marriage. In response, the Ministry of Justice made major legal changes to tackle this matter. As of 27 February 2023, the Marriage and Civil Partnership Minimum Age Act 2022 came into force and raised the minimum age for marriage and civil partnerships to 18 years old. It is now illegal to arrange a marriage for children whether or not force is used, and those found guilty will be sentenced up to 7 years in prison. This act also amends the Antisocial Behavior, Crime and Policing Act 2014, making it an offense to force a child under 18 into marriage with not only physical violence but also psychological violence. The legislation extends its protection by criminalizing the act of bringing someone overseas to coerce them into marriage, a practice that has been a major concern in certain communities. The Minister of Safeguarding, Sarah Dines, MP, said forced marriage is an abuse of human rights, which denies vulnerable children from the freedom to learn, grow, and thrive. Like all other forms of abuse, I'm committed to stamping out this exploitive practice. The Forced Marriage Protection Order, or FMPOs, are an additional safeguard for children being forced into marriage used in legal systems. The court can make an order in an emergency so that this protection is in place straight away. FMPOs may include restrictions such as seizing passports to prevent forced marriages overseas, and breaching it is punishable for up to 5 years in prison as it is a criminal offense. The law will recognize all those married under the age of 18 as victims of forced marriage, creating a route for identification and reporting of illegal child marriage. An annulment formally states that the marriage is null and void, providing an escape route for individuals who are forced into marriage. If a marriage was never legally valid, the law says that it never existed. Additionally, marriages can be deemed invalid if they fail to comply with legal standards, such as in where one party is below legal age. Overall, the law on child marriage in England and Wales has evolved to protect the rights and welfare of children by raising the minimum legal marriage age to 18 years old and making forced marriages a criminal offense. As said by Natasha Ratu, the director of Karma Nirvana Charity, which is the member of the Girls Not Brides Coalition, the change to the legislation on child marriage is a huge victory for survivors. It is a huge leap forward to tackling this usually hidden abuse and will provide a greater degree of protection to those at risk.
Hi, my name is Yong Jing Wen, and I'm going to talk about the comparison between the current position of Malaysian and English law. The first aspect that we could discuss is the legislation governing on marriage. In Malaysia, for the non-Muslim, it is governed under civil law, or specifically the Law Reform Marriage and Divorce Act 1976. While for the Muslims, it is governed under respective state Islamic family laws. In English law, the current statutes that provide a minimum age for marriage is the Marriage and Civil Partnership Minimum Age Act 2022. The minimum age for the non-Muslims in Malaysia is stated in Section 10 of the Law Reform Marriage and Divorce Act 1976 that provides that the marriage shall be void if at the date of the marriage, either party is under the age of 18 years or for a female who has completed her 16 years, shall receive an authorized granted license from the chief ministers. Moreover, Section 8 of the Islamic Family Law Federal Territories Act 1984 stated the minimum age for marriage for the Muslims. This section provides that no marriage may be solemnized whether either the man is under the age of 18 or the woman is under the age of 16. On the other hand, to compare with the English law, prior to the Marriage and Civil Partnership Minimum Age Act 2022, the minimum age for marriage was stated in Section 2 of the Marriage Act 1949, where the marriage under 16 or 17 shall be void. But this did not adequately provide safeguards to the children. Hence, the Marriage and Civil Partnership Minimum Age Act 2022 that came into force on 27 February 2023 have substituted the word 16 into 18, meaning that the minimum age for marriage has risen from 16 to 18 years old. And under this act, it is also illegal to arrange child marriage whether or not force is being used. Another aspect that we could discuss is parental or judicial consent. In Malaysia, for a non-Muslim, under Section 21, subsection 2, the court may solemnize such marriage by granting a license by the chief minister. Furthermore, the marriage for Muslims shall be approved if the Sharia judge has granted his permission in writing in circumstances. This provided under Section 18 of the Islamic Family Law Federal Territories Act 1984, where the parties who intended marriage is underage shall refer application to the Sharia judge. And the Sharia judge, on being satisfied of the truth of the matters stated in the application and the legality of the intended marriage, and that is the case that merits the giving permission of the purpose of underage marriage. This provided a huge difference in English law, as prior to the Marriage and Civil Partnership Minimum Age Act 2022, Section 3, subsection 1 of the Marriage Act 1949 mandates that all of his parents or other individuals who have parental responsibility for him to provide their agreement for him to enter into the marriage. But in the Marriage and Civil Partnership Minimum Age Act 2022, Section 3 was omitted. In other words, regardless of parental or judicial consent, marriage under 18 years old is strictly prohibited in English law now. Following, we could also compare some other statutes in Malaysian and English law that provide some safeguards to the children. In Malaysia, there are Children Act 2001 and the Sexual Offences Against Children Act 2017 to provide safeguards and protection to the children, but both of the legislation does not explicitly mention on child marriage. This is a point that might be used to justify that child marriage is outside the purview of children's sexual exploitation, and child marriage is rarely to be seen as sexual exploitation.
Hi, my name is Liew Xin Yi, and I'll be discussing whether the Malaysian government should address child marriages in the country under the Sexual Offences Against Children Act 2017. Undoubtedly, child marriages are detrimental to the physical and mental health and well-being of children, especially girls. Considering the current movement of stamping out the harmful practices of child marriages in England and Wales, it is pertinent for Malaysia to address and amend the law to address child marriages and the issues arising from them. Doing so falls in line with UNICEF's support in ending child marriage in Malaysia, as well as Article 16 of the Universal Declaration of Human Rights. England and Wales have passed legislation, namely the Marriage and Civil Partnership Minimum Age Act 2022, that prohibits child marriages, including those with parental consent. There is now a stark difference between the laws of England and Wales and Malaysia, where England and Wales have increased the marriageable age to 18 with the intention of eradicating all child marriages. In contrast, Malaysia still remains in the position of allowing child marriages, where child marriages are regulated under the Islamic Family Law, Federal Territories Act 1984, and respective state Islamic family laws enactments for Muslims, and the Law Reform Marriage and Divorce Act 1976 for non-Muslims. Notably, Malaysia has ratified both the United Nations 1989 Convention on the Rights of the Child and Convention on the Elimination of All Forms of Discrimination Against Women in 1995. However, the very presence of allowing child marriages in Malaysia is a practice contrary to the CRC, which seeks to protect the human rights of children. Furthermore, it is clear that the CEDAW has not been fully implemented, taking Article 60, Part 2 into account, which states that the betrothal and the marriage of a child shall have no legal effect. To implement these conventions, the best and most ideal steps to be taken by Malaysia are those of amending the current laws to enforce the human rights of children and prevent tragedies from happening, such as cases where children are being forced to marry their rapists, or even cases of children being abused in marriages. For Muslims, Section 8 of the Islamic Family Law, Federal Territories Act 1984, and Islamic Family Law enactments could be amended to raise the marriageable age limit to 18. A remarkable amendment has been made by the State of Selangor in September 2018, with essential amendments made to the Islamic Family Law, State of Selangor Enactment 23, and the Sharia Court Civil Procedure, State of Selangor Enactment 23, increasing the marriageable age to 18. However, underage marriages are still permissible by the Selangor Sharia Court in response to application made by the guardians or parents of the child. Indeed, raising the minimum marriageable age is a positive step forward. However, to promote uniform law for all Muslims in Malaysia, it is proposed that all states amend their Islamic family law enactments to increase the marriageable age limit. More importantly, it is suggested that underage marriages are wholly and completely disallowed irrespective of the consent of guardians, parents, as well as Sharia court judges, so as to follow the promising direction of the Marriage and Civil Partnership Minimum Age Act 2022 in England and Wales. Ideally, several legislations could be modified to eradicate child marriages for non-Muslims, especially the Sexual Offences Against Children Act 2017, as well as the Law Reform Marriage and Divorce Act 1976. A suggestion would be to amend the Sexual Offences Against Children Act 2017 in order to make child marriages a crime. Section 2 of the Marriage and Civil Partnership Minimum Age Act 2022, which amends Section 121 of the Anti-Social Behaviour, Crime and Policing Act 2014 may be referenced to do so. The result of such an amendment would be to abolish all child marriages, including those with the consent of persons currently stated in Section 12 of the Law Reform Marriage and Divorce Act 1976. A similar effect to the Marriage and Civil Partnership Minimum Age Act 2022 is aimed to be achieved, criminalizing everyone who aids and abets child marriage, regardless of whether the child is willing to be married. Crucial amendments shall also be made to the Law Reform Marriage and Divorce Act 1976 to ensure consistency in the law. As recommended by both the CRC and CEDAW, the minimum age of marriage for both boys and girls is at 18. In the Law Reform Marriage and Divorce Act 1976, a minor is defined as a person who is under the age of 21 years and who is not a widow or widower. To avoid confusion, it is suggested to amend this definition in the Act so that a minor is someone who has not attained the age of majority, which is 18. There seems to be inconsistencies in the age of majority present in the several other Malaysian statutes through the definition of child, such as the Children and Young Persons Employment Amendment Act 2010, the Adoption Act 1952, and even the Guardianship of Infants Act 1961, which defines child differently for Muslims and non-Muslims. It may be ideal for there to be a legal definition as to the definition of minor in Malaysia, even though there are indeed statutes stipulating the age of majority to be 18, such as the Age of Majority Act 1971 and the Child Act 21. Furthermore, Section 10 of the Law Reform Marriage and Divorce Act 1976 shall be amended, removing the text unless, for a female who has completed her 16th year, the solemnization of such marriage was authorized by a license granted by the Chief Minister under subsection 21, clause 2, so that all marriages where either party is under 18 are void. Section 12, subsection 5, Section 16, subsection 1, clause B, subclause 2, Section 21, subsection 2, Section 22, subsection 3, clause A, subclause 2, and Section 69, subsection B of the Act shall also be removed, as they shall be inapplicable after all child marriages are eradicated. It is also notable that the proposed amendment to the Sexual Offences Against Children Act 2017 could also instead be inserted into the Law Reform Marriage and Divorce Act 1976, most likely achieving the same effect. Furthermore, it shall be ideal to remove Section 4, subsection A of the Age of Majority Act 1971, which provides the effect of allowing underage marriages. Overall, it may not be enough for the Malaysian government to only address child marriages in the country under the Sexual Offences Against Children Act 2017. It shall also be instrumental to make amendments to the Sharia laws and other legislations, especially the Law Reform Marriage and Divorce Act 1976, in order to uniformly abolish child marriages regardless of religion, conforming with the principles enshrined in the CRC as well as the CEDAW.
In conclusion, child marriage remains a significant issue, especially in Malaysia. The number of child marriages reported in Malaysia remains to be a substantially high number. This raises serious concern, which emphasizes the urgent need for legal reforms to protect the children in Malaysia from the sexual exploitation and deprivation of opportunities in child marriage. Although Malaysia has enacted laws like the Child Act 2001 and the Sexual Offences Against Children Act 2017 to protect children, these laws do not directly address child marriage. The combination of civil and Islamic laws, each with its separate minimum marriage age of its own, blurs the legal framework and affects child protection measures. However, in comparison, England and Wales have made major legislative reforms to child marriage, which led to the enactment of the Marriage and Civil Partnership Minimum Age Act 2022. This act establishes the minimum marriage age at 18 years old without exceptions, criminalizes forced marriages, and provides significant safeguards through forced marriage protection orders. These improvements might serve as a model for Malaysia by offering a comprehensive approach to protecting children's rights and well-being. Overall, to successfully tackle child marriage, Malaysia needs a single legislative standard that raises the minimum marriage age to 18 years old in all jurisdictions, without exceptions. Malaysia can accomplish significant change in eradicating child marriages to protect its own children's rights by aligning its laws with international conventions such as the Convention on the Rights of the Child and the Convention of the Elimination of All Forms of Discrimination Against Women. Thank you.